Welcome to the channel. Hey there, I'm Kelley Norton, and I am a 23-year real estate agent here in the Valley and a Valley native. And today we have another episode of the Legal Talk here with David HagEstad. So the video is going to be about owning personal property in a trust versus will and personal name. So stay tuned. We will be right back with a full video.
Hi, I'm Kelley Norton, your AZ Realty lady at EXP Realty. Count on me for all things Arizona real estate.
If this is your first time to my channel, again, I'm Kelley Norton. I'm an associate broker here at EXP Realty, and I help people just like you that look to relocate to or within the Phoenix and surrounding areas. So whether you're looking for your snowbird home, you're looking to retire, this is your first home you're buying, or maybe you're selling a home and buying another one here in the Valley, please reach out to me, call me or text me. It is the best way to reach me. But stay tuned on this video because he's going to explain a lot of information for you with regards to trusts and wills and taking property in your personal name versus those protection vehicles. So let's go ahead and dive right in, David.
Okay. Well, hi, I'm David HagEstad. I'm one of the partners at HagEstad Law Group. We serve the Valley. We serve here in Phoenix, and also we have an office in Missoula, Montana. So if you're from Montana, give us a call too. We specialize in estate planning, probate, real estate issues, and other litigation stuff. And we really love talking about different ways to protect your assets. It's a really good time.
Yeah, absolutely. And that's why we're sharing this with you today, because we do have a lot of people that will come to us, purchase a property, and they don't have anything in place. They don't have a trust. They don't have a will. So when you have someone that comes to you that wants to purchase property, give some advice to the viewers on the benefits of having a trust and a will, or what the differences are between the two, or taking property in their personal name versus those vehicles.
Yeah. So the first basic thing, and I'll give you just a quick scenario. Normally what I do is I'll get a call and it'll be somebody saying, hey, I'm looking to purchase property. And I'm trying to figure out if at this stage of my life I should do some estate planning, or is there some way to take title to the property that will keep it out of my name, something like that. And that's when I start to go, okay, yeah, well, let's talk about this. So the first thing that you need to understand is there is a big difference between a basic will and a revocable living trust. Yeah. Okay? The first thing with respect to the will is a will is not effective until you die. So it's just a piece of paper until you pass away. It doesn't mean anything. You can't hold property. You can't, it's basically just a piece of paper until that time, and I hope it's a really long time from now, okay? The next thing is a trust. The basic, most common trust is a revocable living trust. A revocable living trust is vastly different, and I phrase it to people as it's just a figment of legal imagination, because it's a piece of paper just like a will is, but the difference is it can actually own stuff right now. It can own your bank accounts, it can own your house, it can basically take over all the assets that you own, take it onto itself, and it own those things. And there's a really good reason for doing that. It helps avoid probate. There's ways to help avoid taxes. There's a lot of really good things to do that. But those are the two fundamental differences between a will and a trust. Is a will says what happens, but it says what happens in probate. It does not avoid probate. A revocable living trust can own things right now and actually help you to avoid the probate issue. And it can actually own your house. It can own rental property. It can own pretty much anything a person can own.
Okay. And I think for some viewers, they might even know what probate is. So why don't you explain what probate is? I've had clients where, they had to go through probate before they could sell their home.
Right.
Cost them a ton of money.
Yeah, it does. And actually in Arizona, it's particularly difficult to probate issues, and we can get into that in a second. But a probate basic is that if your estate is valued at $75,000 or higher in personal property, or $100,000 in equity in real property, and that's an or situation, 75 or 100, your estate is going to go to probate. It's required by Arizona law. And so unless you do something, unless you use some vehicle as beneficiary deeds, payable on death accounts, or a trust. And so a probate is really just an informal court case. You have to file a petition. The person, well, not you because you'll be passed away, but the person coming after you, it's called a personal representative. They will file an application for probate to admit your will or whatever documents you have to get the court to say that you can transfer your assets, or they can transfer your assets after you've passed away. That's a probate basic. It's a court case, and everything that you have and everything that you own becomes public record.
And it can vary on how long that takes.
Oh man, yeah.
Right.
So, it can be.
Depends how much is at stake, right?
It could be 6 months. It could be 18 months. It could be longer. It depends on if there's, disputes between the beneficiaries, creditor issues.
Yeah.
Is the market bad or good for selling real property? I mean, do we hold it? Do we sell it? What do we do? So probate is it can be a lengthy process, and by and large, it's far more expensive than estate planning.
Right.
And so it's time. It takes a lot of time, especially in Arizona, because what is Arizona known for?
Yeah.
We people come here because of the weather, right? So they're like,
Yeah.
I'm sick and tired of the weather in Minnesota. I'm sick and tired of the weather in Michigan and New York and Washington State. And
big percent of clients.
I have a lot of clients that come from our Montana office that come down here to Arizona. And so they're tired of the cold weather. They come here to retire.
Yeah.
Right. And so we have a lot of these 55 and older communities. We have people coming into the area. Unfortunately, they end up passing away. So here in Maricopa County, especially, we have a backlog of probate cases. We don't have that many probate. They're called probate commissioners, but they're basically probate judges. We don't have that many. And usually there's between 21 and about 25,000 probate cases pending in Maricopa County at any given time. And for the amount of probate commissioners we have, that's entirely too many. It's a couple thousand probate cases per commissioner.
Oh, wow.
That's too many.
So, David, oftentimes I'll have people come to me that don't have any estate planning. They haven't been through that process and they want to purchase a home. So what type of advice can you give to that future homeowner?
Yeah. And like you said, that is actually really common.
Yeah.
Most people don't have any estate planning. 60% of Americans are going to die without a will. So if this happens a lot, people will come to my office and say, okay, we're under contract for a house, or we're looking for homes right now, and we want to know if there's a different way that we can take title to the property as opposed to putting it in our name. And the most common thing is going to be just setting up a revocable living trust. And people will ask me, well, should I buy the home and then set up the trust, or do I set up the trust and then take the home at time of closing in that way? And I always tell you, if you have the ability and you have the time, set up the trust now, simply because it makes things easier going forward. There's less for you to do. You don't have to get another deed drafted to transfer the home over to your trust. It's just at the time of closing,
there you go.
Title's going to prepare a deed in the name of a trust as opposed to your own personal names. And a lot of people are like, oh, well, that makes me uncomfortable. Like, it's my house. I want it to be in my name. No, you don't.
Right.
Okay? Just know that. You don't. You want it to be in a trust that you control. And so that's a big thing. And if you want to know what I meant by a trust you control, give me a call. But so going ahead, if you have the time to do it, get the trust established first, just because it saves on steps in the future, and it helps to avoid that whole probate process.
Right.
Because one of the things that I never count on people to do is actually follow through on taking additional steps. Right. Yeah. We're all just like, oh, I'll get to it. Right. But if you just go ahead and take the time now and get it done, it saves all these steps in the future.
Well, and after people close on their house, there's a million things that are going on. They're,
in that time period, I've talked to so many people that are just like, I don't even want to do this anymore. Like, buying the house, go ahead and get the trust and have everything set up, and then start transferring the assets into your trust. It will make life easier.
Okay, perfect. Now, I have a question for you, because someone asked me this the other day. So they said, if they pass away, what happens to the mortgage payment? Who pays that? Is it due? Does it go away? So I'll let you answer that to the viewers.
So there's, just because you transferred the home into the trust doesn't mean the mortgage payment isn't still due, because the mortgage isn't in the name of the trust. The deed is, okay? And they're two different things. Right. So the mortgage payment is still due, and you still have to pay it. And so say you pass away, there's no more trust, the successor trustees coming in and say it's your child or something like that that's now managing your trust for you after you're gone. They still have to pay the mortgage too. The mortgage still has to be paid. Now you can contact the mortgage company if there are issues, if there's funding issues. Typically the mortgage company is going to want to work with you.
Yeah, they typically do.
Yeah. They'll pause payments. They'll help you to get the house sold, whatever it is. But yes, mortgages still have to pay it. You're still obligated because the mortgage is in your name. The deed is not. So.
Perfect. Okay. Now, so I had this question the other day too, different client, but I love the questions because then I can ask these live on camera because a lot of viewers have the same questions. So what happens if the trust doesn't have enough to pay all of the bills or something that someone has that's keeping occurring, or there's things that need to be paid off and the heirs are they responsible? This was the question was, if we don't pay that and we just let the car foreclose, or we want to give, or, I don't know if foreclose is the right word, but give the car back, what happens there? Does it end up going on the credit of the person who inherited these things, or no?
No, ma'am. No. So it's solely for the estate or the trust or whoever actually owns it. The beneficiaries are not obligated for like your parents' debts. You're not going to, you don't inherit their debts. Now, the one caveat to that is say there's a house, there's a mortgage, and the kids all receive the house, but they stop paying the mortgage. Okay. Mm-hmm. Then you do. Right. As a beneficiary, you have an obligation to pay the mortgage now.
Yes.
And if it's not paid, then
of course, yeah,
the mortgage holder or the creditor is going to come after you, and to the extent of your interest. So say there's 3 kids, each kid takes 1/3 ownership in the property. Each kid that inherited 1/3 of the house is also going to inherit 1/3 of the debt on the home.
Yeah,
and you're only liable to the extent of your what you receive, but you will be responsible for it. Now, if there's nothing, if there's just a small estate, there's nothing left, the debt is too high, and you don't take anything, then the beneficiaries typically are not held responsible.
Okay, no, it makes sense. Another scenario to run by you here is, let's say that someone, they purchased a house, they don't have a trust, but the home is completely paid off. And I've had some folks, call me and say, hey, we need to talk to a title person because we want to add our children on. That way, when we pass away, they own the property. So what would your advice be to someone that's trying to go that route and just adding them to title because there's no mortgage involved, it's paid off, rather than actually having one of those separate vehicles, paper vehicles to protect them?
I would not advise anyone to give their children an active ownership interest in their home, unless inevitably, if that's what they want to do, that's what they would do. Okay. Right. But my job is to provide you with advice and counsel, what I think is in the best interest of you. It's probably not going to be doing it that way. There are other ways. Okay. And the very common way is just executing a beneficiary deed.
Yep.
And a beneficiary deed just says they have, at the moment I pass away, this house is now theirs. And it's a vehicle that is effective at avoiding probate. Okay. And it's a pretty simple process, as opposed to giving them an ownership interest right now. Then they can do, they have a right to the property. They have a right to be in the property. They have a right to partition the property, like we talked about it in another video.
Yeah.
Gets scary. It gets scary. You're giving people
a lot of control.
You're giving people rights.
Yeah.
And when you're giving people active rights, you need to understand that means you are giving up rights.
Yep.
So I would probably never advise a client to add a child's name to a house or a bank account or something like that actively. I would either make it payable on death or a beneficiary deed.
Okay. And so let's say, here's a scenario where, let's say buyer A received funds from a trust from a parent that had passed away.
Okay.
They are purchasing a home, and then they get married, and they used those funds from a parent's death to purchase this home, and now they're getting married, and that person wants to be put with ownership on the property. What would be the best way for someone to protect the funds that were used to acquire that property, or is it already protected because it was a trust?
So it's not necessarily protected in that it was because it was from a trust. It's an inheritance of some kind. So it would still be that one spouse's separate property that they invested. Whether or not they took the property joint tenancy with right of survivorship, that will complicate things, but they still have their interest in that separate down payment that they made. And it gets a little bit complicated at that point with the contribution claims and things like that. But it's still theirs. It's still separate property. And if they bought the house solely with that separate property and solely in their name, then the house is solely theirs.
Okay. And so even if they get married then and nothing else was done to give ownership or rights to equity to the partner, then this person, buyer A, is still
sole owner.
Okay.
Yeah. The only complication to that is those contribution claims, anything that the person paid to improve the property or pay off the mortgage or anything like that. But yeah, it's still treated as separate property.
Okay, great. Good information.
And what have you mentioned is I have a lot of people here that own property here. They have homes in other states, and sometimes they move here and then they decide, maybe I do want to get a condo back, for the summer months to stay in back where I used to be, Michigan, New York, Montana,
where it's pleasant in the
Illinois.
summer.
Yes, right. Any of those places. So how does that work with the trust? Can they add a property to their trust that was started in Arizona?
Absolutely, yeah. So a trust in Arizona can own property in Florida, New York, any of the 50 states and territories. It doesn't matter. Actually, it's a great way to avoid probate in multiple states, because that's a big problem when you own real property here in Arizona, you own real property in California. You may end up being subject to probate in both states if you own that property in your personal name. So yeah, absolutely. Put all that real property into your trust if you can, because it will help your estate avoid probate in the future, and it makes your assets so much easier to access for your beneficiaries, for yourself. It's a great way to do it. Yeah, of course.
I mean, is there a benefit of one state versus another for which one you have your trust in or start it in?
They're all pretty. Most states have adopted the model uniform probate code or trust code.
Okay.
So it's all largely the same. There's really no. It's not like with businesses. Like a lot of businesses want to start in Nevada or Delaware. Or Wyoming. Wyoming's kind of an up and coming place. A lot of people want to start up in Montana too, because there's no sales tax. There's lots of good reasons, but for purposes of the trust itself, not really.
No real advantage one state versus another.
Yeah, for a standard revocable living trust, other states it's more beneficial for irrevocable type trusts. Like Arizona, we can do more complicated trusts if you have higher net worth. We can do things, it's called a dynasty trust here, to try to avoid some taxation, make sure that things easily flow through to your next generations. That's why it's called a dynasty trust. Other states, it may be called a legacy trust. With respect to revocable living trusts, the law across the United States appears to be pretty well standard. Irrevocable trusts for more complicated people that are going to be concerned about, estate taxes, business interests, and things like that. It does make a difference. Arizona's a good state for estate planning in that way, because we do have things like dynasty trusts that are permitted. There are other states where they're not, and trying to avoid taxes is far, far more difficult.
Yeah, definitely.
Well, thank you so much. Just a wealth of knowledge here for the viewers. So I greatly appreciate it, and I know they do as well. So again, guys, this is David HagEstad, and he is available for all sorts of needs. So if you are wanting to have him take a look at a real estate contract, if you need advice on how to take title, if you need an estate planning meeting to get everything set up for you, maybe you're getting married, you want to make sure that you have everything in line and ready to go.
You should.
Yes.
Do that.
Yes, you should do that. Yes. So he is available for you. His information is on screen here. We also have it in the description on the channel. And again, I'm Kelley Norton, and I'm here to help you if you are looking to relocate to or within the Phoenix and surrounding areas. And I always have amazing partners available to help you with anything that you might need. Even once you move into the property, if you have a question, whether that be where to get your hair done, where to go out to eat, legal questions, I am here to always support you and give you information throughout the time that you live here in your home and in Arizona. So thank you again. Call or text. It's the best way to reach me. Remember to subscribe to the channel, and click that little bell. That way you are notified when I put up new videos. Take care. Thanks so much. Bye-bye.